Pregnancy and human rights. The Human Rights Act, the Act, protects New Brunswickers against sex discrimination in employment, housing, services, and memberships in unions and professional or business organizations. This includes any unfair treatment related to an individual's pregnancy. Pregnancy discrimination meaning. Under human rights law, individuals are protected from discrimination based on their pregnancy or the possibility of becoming pregnant. Possibility of pregnancy means that people of childbearing age are also protected under the Act if someone discriminates against them based on the assumption that they might become pregnant. Example: an employer refuses to hire a young woman for a managerial role because they assume that she may become pregnant soon. Protections against pregnancy discrimination also cover the entire period from conception to post-birth recovery, including any pregnancy-related conditions. Example: if an employee experiences complications from a miscarriage and requires time off to recover, the employer cannot treat them differently or penalize them for taking the necessary time to heal. Pregnancy-related situations protected under the Act may include the following: health problems from pregnancy or childbirth, abortions and any complications from it, miscarriage, stillbirth, and related conditions, fertility treatments or family planning, recovery after childbirth for a reasonable amount of time, breastfeeding. Pregnancy discrimination. Under human rights law, employers are prohibited from, at the pre-hiring and hiring stages, rejecting a candidate because they are pregnant or might become pregnant, posting job ads that discourage pregnant or potentially pregnant people from applying, asking about pregnancy or plans to have children during an interview or job application, withdrawing a job offer after learning the person is pregnant, refusing to hire someone for a short-term position because their maternity leave will start during the contract period. During employment, not renewing a contract because of an employee's pregnancy, refusing a promotion because an employee is pregnant, demoting, firing, or laying off someone because they're pregnant, changing job duties or working conditions that force a pregnant employee to quit, harassing pregnant employees, assuming a pregnant employee can't do their job without a proper assessment, penalizing an employee for being pregnant, whether married or not, disciplining an employee for asking for pregnancy-related accommodations. Under human rights law, pregnancy discrimination is also prohibited in housing, services, and associations, etc. Right to breastfeed. Breastfeeding is recognized as a right under human rights law, and individuals should not face discrimination for breastfeeding or expressing milk. In fact, breastfeeding is a health issue, not a matter of public decency. This means that individuals can breastfeed in public without being asked to stop or move elsewhere. Employers, housing providers, associations, and service providers must take steps to support breastfeeding individuals, including providing a private space for breastfeeding if requested, allowing longer breaks or shorter work days for breastfeeding needs, permitting infants in the workplace for breastfeeding, offering storage spaces for expressed milk, providing adequate seating for breastfeeding. Note: employers cannot ask an employee to provide medical documentation to support their need to breastfeed at work. Duty to accommodate. Under the Act, employers, service providers, associations, and housing providers have a legal obligation to make reasonable adjustments to their policies, practices, and spaces to accommodate individuals based on their pregnancy. This means that they must ensure that pregnant individuals can work, live, and access services without difficulty or barriers. This is called the duty to accommodate, and it is the law. Undue hardship. If it becomes too difficult for an employer, service provider, or housing provider to accommodate an individual's needs related to pregnancy, for example, due to extremely high financial costs, then they may deny the accommodation request. Such denial must be based on careful assessment. It cannot be automatic. This is called undue hardship. In some cases, discriminatory practices may be justified if they are based on a bona fide requirement, BFR. A BFR is a rule or condition that is truly necessary for the job, service, or housing, and is essential for the safety or proper operations of a workplace or service. A BFR can only be used if there is no other reasonable way to accommodate the pregnant person without causing serious difficulty, undue hardship. Examples of pregnancy-related accommodations: providing alternative tasks if the regular job involves heavy lifting or safety-sensitive activities that could pose risks for the pregnant person. Allowing pregnant employees to adjust their schedules to accommodate medical appointments or for pregnancy-related symptoms. Modifying a workstation to address pregnancy-related symptoms like back pain. Allowing time off in the case of a miscarriage, stillbirth, or abortion. Providing a designated private area for breastfeeding or allowing individuals to breastfeed in common spaces without restrictions. Do you have questions? Contact the Commission. The New Brunswick Human Rights Commission is a government agency that ensures that the human rights of everyone in New Brunswick are protected under the Act. To learn more about your rights and responsibilities related to pregnancy, contact the Commission. The Commission provides free information about your rights and on how to file a human rights complaint. If you think you've experienced discrimination in New Brunswick, you can file a complaint with the Commission. You can reach us at 506-453-2301, hrc.cdp@gnb.ca, www.gnb.ca/hrc-CDP. Learn more about pregnancy and human rights by consulting our guideline on pregnancy discrimination.